Hello and welcome to today's episode of Justice Bytes, a series where we look at how Maurice Blackburn is making a difference in the community. I'm Jennifer Canis and I lead the firm's social justice practice. And today I'm joined by John Rule, a principal lawyer in our abuse law team. Welcome, John.
Hi, thanks for having me.
Tell me a little bit about what abuse law is.
So in the abuse law practice, we run civil damages claims for people who've been abused as children, and it's generally people who are now adults who were sexually or seriously physically abused as children, almost always in an institutional context, but we also sometimes pursue claims against the perpetrators, the individual perpetrators as well.
And so I've been hearing about this defence called the dead man's defence. What is it?
So it's a name that's been given to permanent stay applications.
What's a permanent stay?
So it's an inherent power of the court to stop a legal proceeding if it's too unfair on one of the parties for the matter to go to trial. So in practice, that really means in abuse cases, it's where a defendant, an institution is saying, this happened so long ago and there's not enough witnesses or documentary evidence for us to fairly actively take part in the trial, and therefore it should be stayed early on a procedural basis.
And so we know so much now about institutional abuse and how it was hidden and how people were, prevented from coming out about what's happened to them. What's the impact of this stay on the clients that you see?
Well, it can be totally devastating for a few reasons, particularly where the defendants start to use these stay applications strategically, and they start to use it in a sort of attrition kind of way to wear people down and use it as a threat to try and get plaintiffs to accept low settlements. And so it's just another barrier and another legal technicality that big institutional defendants and defendant law firms are now using to try and escape liability in these cases.
And can you give me an example of where that's happened?
So there's a lot of examples, but some of our clients in particular, two examples come to mind. One is a matter where we were suing the Christian Brothers, and our client was abused by a Christian Brother teacher when he was in year 7. The Christian Brothers, halfway through the litigation, put on a stay application saying the perpetrator was dead, which was true, and 3 other really important witnesses were also dead. The principal of the school, the brother who was in charge of keeping records, the archivist, and another important teacher who was apparently a witness. We found out that 3 of those witnesses were alive and well and were available to give evidence. So the Christian Brothers had put on a stay application. Their lawyers had gone on affidavit exhibiting death notices and so on for these people, and we were able to find those people through our investigations, and ultimately they withdrew that stay application.
And so what have you been doing to try and address that issue? Because it must come up a lot in abuse cases where there's such a long time between the abuse and then someone coming forward.
It comes up a lot, and there are some cases where I think stays are appropriate, and some cases that probably shouldn't be brought before the courts have been stayed correctly, but those are very, very rare, and stays are only supposed to be used in exceptional circumstances. And defendants certainly, particularly prior to a recent High Court decision, defendants were using them far too often and in situations that just weren't appropriate for what stays are intended to be used for. And so what we had to do as the plaintiff's lawyers is spend a lot of time and resources investigating these matters, chasing down leads, finding witnesses, running ads in papers and online, using private investigators, using teams of paralegals and lawyers to track down witnesses to try and combat these stays. And we were lucky that we had the resources at Maurice Blackburn and the leadership and the inclination to actually pour the resources into doing that. But it did create an extremely unfair situation where plaintiffs were essentially having to go out and almost do the defendant's job for them in finding these witnesses that ultimately might assist the defendant in a trial in order to overcome this stay application.
And so if you hadn't have done that work, those people would have never seen justice.
No, that's right. And it was good that we were able to get our clients over the line in those cases, and we did feel equipped to stand up to the defendants when they were throwing around stays as a threat, as a tactic to try and get us to take, or our clients to take, lowball settlement offers. But there are a lot of law firms out there who don't have the resources or the inclination to do that, and a lot of their clients, who are also survivors of abuse, who took settlements that were unreasonable and unfair, or who haven't made claims because of a fear of the permanent stays.
The defendants still using these stay applications in the same way as they have been in the past, or are we seeing any changes in the law or in behaviour?
So there was a really important High Court decision that came out at the end of last year called GLJ and the Diocese of Lismore, the Catholic Diocese of Lismore. And the High Court in that matter came down on the side of GLJ, the survivor of abuse, and it was and gave some really, really important guidance for this area of law, for stays and how they're to be used, and how historical abuse cases are to be approached more generally. So that was very helpful, and that did put defendants a little bit on the back foot, although almost immediately defendants and conservative commentary started talking about the fact that it was a split decision in GLJ. It was 3-2, and it was only 5 sitting judges as opposed to the full court. And there was a lot of chatter from the defendants that they were waiting for the right stay case to take to the full bench, and that's now happened in that two cases, one out of Western Australia, a Salvation Army case out of Western Australia, and a State of Queensland case, have now been heard by the High Court, and the decisions are due down in September.
John, I'm really interested in your practice and the focus on institutional abuse, and really how, I guess, what motivates you to do the work, how you keep yourself motivated.
It's not for everyone, and we've had people come into the team, even experienced operators, who have assumed they'll be able to cope with it, and it's not for them, and that's totally okay. So we're very careful to make sure we're checking in with staff always. But I think you've got the right personality for it. If you're someone like me who can compartmentalise and who can treat it like a professional problem to be solved, and think about the role as getting the absolute best result for this particular client through legal recourse. If you can do that, then it's an incredibly rewarding area to work in, and I really see it as an absolute privilege to do the work and to have clients who trust you to act for them, and really we become their sword and shield, and I love it. It energises me, and I think the people in my team are energised by it too.
So institutional abuse has been in the media a lot. There's been plenty of inquiries. But what's actually happening on the ground?
I think the reality is, unfortunately, that defendant law firms and institutional defendants who've been involved in abuse for a long period of time, state governments, Catholic Church entities, Salvation Army, etc., they like to involve themselves in inquiries and royal commissions and be seen to do the right thing. But unfortunately, the reality of litigation in this area is we have to assume the worst of them, and they generally deliver on that, and we have to assume that they're going to use whatever legal tactics they can to try and avoid liability. And it's our job to hold them accountable and to make sure that our clients have a voice and that they get the compensation they deserve.
John, I often wonder about our clients in this area and, marvel at their resilience. But I wonder why they come forward and speak to a lawyer now.
We have a whole range of clients from all walks of life. We have a lot of clients who are formerly state wards who've come from very tough backgrounds even before the abuse, and many of them go on to have very, very tough lives in jail, serious mental health issues, in and out of hospitals, those sorts of things. But we also have clients who've been abused at prestigious private schools who've gone on to be surgeons and businessmen and so on. The impacts are varied, but it has a major impact on all of their lives. And it's a devastating thing to happen while someone is going through those formative years. And our job is to hold the institution accountable and to get these people the justice they deserve.
Thank you so much for joining us today. It's been a really interesting discussion. For people watching, please keep an eye on this High Court decision coming down in September 2024. But if you'd like to hear more about the fantastic work that is being done at Maurice Blackburn, please keep an eye on our website and keep an eye out for our next episode of Justice Bytes.